Today, I'm going to talk about the implications of HIV criminalisation, notably its detrimental effects on human rights and public health. And then I'm going to show you how we came up with a solution to mitigate some of these harms. And finally, I'll briefly address the implications for punitive responses to COVID-19. The HIV Justice Network is a global information and advocacy hub for individuals and organisations working to end the inappropriate use of the criminal law to regulate, control and punish people living with HIV. That's what we mean by HIV criminalisation. We also coordinate the HIV Justice Worldwide Coalition, which campaigns to end this HIV criminalisation. At the HIV Justice Network, we learned early on that video can convey advocacy messages far more powerfully than the written word. So to begin the harms, here's a short clip of a video we made to launch the HIV Justice Worldwide campaign.
HIV criminalisation laws are always stigmatising and in many instances are overly broad. This has the effect of placing people living with HIV at extreme risk of a very broad range of human rights violations.
Well, so many of these investigations and prosecutions are selective and arbitrary, and they often have a disproportionate impact on racial and sexual minorities, trans and gender non-conforming folks, migrants, and certainly women.
Sometimes HIV criminalization can be used to control, to abuse, or to retaliate against a former or current partner living with HIV by threatening to go to the police.
HIV criminalization is horrible public health policy. You can't be prosecuted if you haven't been tested. So it's become take the test and risk arrest.
Not only do a significant number of new infections come from people who are undiagnosed, testing is also the entry point for treatment and care if you're positive, and prevention services including PrEP if you're negative. Patrick O'Byrne is lead author of the 2013 Social Science Review article, HIV Criminal Prosecutions and Public Health, an examination of the empirical research. He's also studied the impact of HIV criminalisation on gay men and documented how it has impacted their testing and sexual practices.
So, unsurprisingly, you have lower rates of testing, you have higher numbers of sexual partners, you have more unprotected sexual context. Really compounding this, however, were the qualitative interviews we did. Nobody could make a distinction between the public health department and the police. And this is problematic, right? How can you provide healthcare services when people think that you are a police agency? How do you provide care when people won't access it? Right? So the people who are supposed to be there to do HIV prevention can't. They absolutely cannot, because you can't provide services to people who aren't in clinics. Like, the laws have effectively rendered your HIV prevention health professionals useless.
With the increasing rollout of molecular HIV surveillance and the fact that medical records can always be used as evidence in court, HIV criminalisation also seriously impinges on the relationship between people diagnosed with HIV and their healthcare providers. The HIV Justice Network has been undertaking global monitoring of laws and cases for more than a decade. The Global HIV Criminalisation Database is a new interactive interface now available on our website. The majority of criminal cases around the world are based on potential or perceived exposure to HIV, and verdicts often fall short of being fair, rational, and just. This is why, for example, we have seen prosecutions for biting, breastfeeding, spitting, and cases like these.
In Canada, a woman living with HIV who had an undetectable viral load was put on trial for aggravated sexual assault for briefly letting a man perform oral sex on her.
In Malawi, a woman living with HIV was prosecuted for breastfeeding.
In Texas, there's a man with HIV who's in prison for 35 years for spitting at a cop.
In the US, a woman living with HIV was raped. She was so afraid of being prosecuted for not disclosing her HIV status to her rapist that she decided not to report it to the police.
Despite global policy guidance to limit HIV criminalisation, it was clear to us that too many laws and cases were fundamentally unjust because they didn't reflect up-to-date HIV science. So we conceived of a document that could support expert witnesses and educate lawmakers and criminal justice system actors, partnering with colleagues at IAPAC, IAS and UNAIDS to make it a reality. 2 years ago, the Expert Consensus Statement on the Science of HIV in the Context of Criminal Law was published in the Journal of the International AIDS Society. Authored by 20 of the most eminent HIV scientific experts, endorsed by another 70 leading scientists around the world, the statement clearly and authoritatively describes current evidence on HIV transmission, treatment effectiveness, and forensic science in a way that's relevant for criminal law contexts. The statement was launched at a press conference during AIDS 2018 and made an immediate impact. More than 50 mainstream media outlets across the world ran the story. These articles finally got the message across that HIV criminalisation is both unscientific and poor public health policy. The reason the message was heard clearly and was so widely disseminated was because it was delivered by leading HIV experts from all over the world, rather than by activists like me. We filmed the expert authors meeting in person for the first time at IAS 2017 in Paris.
A statement like this for me is really necessary because we found out that not everyone is very well informed where we are in terms of science.
We thought it important to state those facts, to state what we know from a scientific perspective, in order to provide the evidence for the justice system and the legal systems in countries to use it as they wish.
I think we need to bring our science into justice. And we need to be sure that it is understood and that it has the liberating quality that certainly it has had for all of us in the scientific world. It's time for the legal world to understand the current science of HIV.
There is no doubt that this is important knowledge to get out to the broader world. It is our responsibility as people who are immersed in the science to make sure that every sector of the world is aware. And in that way, I believe that people can be treated fairly and equally and justly throughout the world.
My colleague, Sally Cameron, who also coordinated the process of putting the statement together, recently undertook a review, published this week, to examine the impact of the statement since then. To be honest, it's exceeded all of our expectations. Not only has it been used to head off prosecutions and support defence arguments all over the world, it's also been used to strike down Colombia's HIV-specific criminal law and is currently supporting strategic litigation efforts in Kenya, Lesotho and Uganda. In fact, the statement has successfully shaped law and policy reform in Belarus, Burkina Faso, Canada, the Czech Republic, Morocco, and Zimbabwe. A number of the statement's authors have gone on to provide expert testimony in key court cases, and the New York Times published an influential op-ed piece co-authored by Chris Byra with HIV criminalisation survivor Robert Suttle. Of course, it would be naive to pretend that science alone will end the unjust laws, policies and practices that lead to HIV criminalisation, as well as the many other unjust punitive responses to populations disproportionately impacted by HIV. So we need to ensure that social, racial and economic justice and human rights arguments are heard too. That's more important now than ever, given the pandemic of bad laws, policies and overly zealous law enforcement that we're seeing as a response to COVID-19. HIV criminalisation is often cited as a model for such a draconian and ill-thought-out response. HIV is not a crime, and COVID-19 is not a crime either. That's why the HIV Justice Worldwide Steering Committee published a statement in March about lessons learned from our experiences working to end HIV criminalisation. First, criminalisation is not an evidence-based response to public health issues and often does far more harm than good. Second, Criminalisation disproportionately impacts the most marginalised, stigmatised, and the already criminalised people and communities in society. Third, measures that are respectful of human rights and the empowering of communities are more effective than punishment and imprisonment. And fourth, communicable diseases are public health issues, not criminal issues. To conclude, it is more critical than ever to commit to and respect human rights principles, ground public health measures in scientific evidence, and establish partnerships, trust, and cooperation between scientists, law and policymakers, and the most impacted communities.